26 exclamation marks. 26 from a judge so exasperated at Trump's legal argument. Let's discuss. I'm Dave Aronberg, former state attorney for Palm Beach County, a.k.a. the Florida LawMan here on Legal AF. Well, this is the first. Normally, judges don't like to put exclamation points on in their rulings. They try to be measured. They're judicial officers. They wear the black robes. They get to carry the gavel, which is cool, and you have to stand up when they enter the room. But they try to be pretty much above politics. But 26 exclamation marks. Yeah, I'm not kidding. I've never seen that. I don't think it's ever been done. But this is what happened from a judge when it came to Donald Trump. This really did. So, according to Mediaite, Trump's order targeting Wilmer Hale, that's one of the big law firms, was struck down in its entirety as unconstitutional on Tuesday by U.S. District Judge for the District of Columbia, Richard Leon, the same judge who eviscerated the arguments by Department of Justice attorneys defending the executive order targeting Jenner & Block, another big law firm, during a hearing last month with an exasperated, "Give me a break." Now, keep in mind, you're seeing a federal judge here react with, "Give me a break," and now with more than 24 exclamation marks, something we've never seen before. Also, it really does tell you that perhaps the big law firms that capitulated should not have capitulated. I know they did so because they worried about their clients and it's a competitive market. But here, the ones who are challenging Trump, standing up to his orders, are winning. They're winning in court, and they are getting recruits who want to work for the firm as opposed to those who are losing recruits. Paul Weiss lost some major attorneys, in part because they capitulated. So there's a dichotomy being set up here. The firms that are playing along with the administration and the firms that are resisting. And I think both sides, I guess, are getting what they want. The firms that are playing along are keeping the clients who threaten to bolt, but the firms who are resisting are winning in court, and they're keeping their people. They're not losing their attorneys. But I guess it'll all shake out after Trump is out of office, and we'll see which firms benefit. But I think we know who's going to benefit in the history books. And here's the decision by the judge. It starts with the following. The cornerstone of the American system of justice is an independent judiciary and an independent bar willing to tackle unpopular cases, however daunting. The founding fathers knew this! Exclamation point. Accordingly, they took pains to enshrine in the Constitution certain rights that would serve as the foundation for that independence. Little wonder that in the nearly 250 years since the Constitution was adopted, no executive order has been issued challenging these fundamental rights. Now, however, several executive orders have been issued directly challenging these rights and that independence. One of these orders is the subject of this case. For the reasons set forth below, I've concluded that this order must be struck down in its entirety as unconstitutional. Indeed, to rule otherwise would be unfaithful to the judgment and vision of the founding fathers! Exclamation point. So you see that Judge Leon likes his exclamation marks. He likes them. He uses them more than other judges do. But when it comes to a point he wanted everyone to know he was emphasizing, he used more than 24. And throughout this ruling, he keeps using those exclamation marks. 73-page ruling. He starts with a flourish. He continues throughout where he just chastises Donald Trump and his executive orders. And then finally he concludes with a footnote. Footnote 35 on page 69. And this is his last use of an exclamation point where he talks about an argument about injunctive relief and who you can add as a defendant. But then he says this. Wilmer Hale also seeks declaratory relief, and Section 702 and 702 does not bar declaratory relief against the United States. As such, I need not and will not dismiss the United States from the case. And that was in a footnote. He's so adamant about using the emphasis that he'll do it even in a footnote. So when it comes to an argument about dismissing the United States from the case because it's not a proper party to the case, he even uses the exclamation point there. And if you're wondering about Judge Leon, thinking maybe he was some Obama or Biden judge, what Democrat appointed him? How about George W. Bush? boy, things are so different than they used to be. I remember when George W. Bush was president, and we thought that he was the greatest threat to democracy. My times have changed. And if you're wondering about the use of exclamation points in judicial rulings, well, according to Mediaite, numerous legal writing experts have long advocated for using exclamation points in only the rarest circumstances, if not avoiding them altogether. Most recommend using them if and only if present in some text that is being quoted. In Jill Barton's 2024 book on the writing of the Supreme Court, she assessed the exclamation mark as the one character on every keyboard with the power to shout, gesticulate widely, and bark, and thus practically forbidden in the civilized world of the law. This punctuation was so exceedingly rare, wrote Barton, it had been used only 10 times in over 10,000 pages of Supreme Court opinions in the previous 5 years. So it is wise to follow the court's lead and nearly always skip this loud punctuation mark. Well, Leon's 73-page written opinion shrugged at such practices, using far more than the 2 exclamation points that Classfeld, that's another observer, flagged. And that was just in the introduction, which I already read to you. It didn't stop there. I mean, for example, Wilmer Hale's First Amendment claims drew forth a flurry of exclamation points from Leon, with the judge exclaiming that out of the 4 counts in the firm's complaint, all survived defendant's motion to dismiss and all warrant summary judgment for Wilmer Hale! Exclamation point. Wilmer Hale alleges that the order blatantly defies this bedrock principle of constitutional law, wrote Leon. I agree! Exclamation point. And it's not just exclamation points. The judge also referred to Creole cooking when he's talking about the court's reasoning. He said the following: the order is akin to a gumbo. Sections 2 through 5 are the meaty ingredients. For example, the andouille, the okra, the tomatoes, the crab, the oysters. But it is the roux here, section 1, which holds everything together. A gumbo is served and eaten with all the ingredients together, and so too must be the sections of the order be addressed together. As explained in this memorandum opinion, this gumbo gives the court heartburn. It also has made this person hungry. So, I'll leave it there. I'm Dave Aronberg, aka the Florida LawMan. If you like this video, please like, subscribe, share with a friend, leave a comment below. Thank you for your support of Legal AF. We continue to generate lots of subscribers, so if you haven't subscribed yet, hit that subscribe button. Let's keep the momentum going, and I'll see you next time.
I'm Michael Popak, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popak Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popak Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event, by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popak Firm today at 1-877-POPAK-AF or by visiting my website at www.thepopakfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popak Firm, fighting for your justice every step of the way.